Hello and welcome to another AIA Contract Documents video. Today we are going to be talking about contractors' rights to obtain evidence of the owner's financial arrangements. My name is Jimmy Germano and I am joined by my colleague Mike Koger. We are both attorneys at the AIA and the Contract Documents program, and today we have the privilege of being joined by our another colleague of ours, Mike Bamba, who is a senior director and counsel also with the AIA Contract Documents program. Before we get started into the substance of this program, we do have to remind everyone that we cannot give legal advice here on this program. More specific disclaimer you will see on your screen. It's also important to remember that today is April 24th, 2020. And what that means is that we are in the middle of the COVID-19 pandemic, and everything is changing rapidly, as always. So it's important to remember that things we talk about today might not necessarily be the same in a couple of days or a couple of weeks or a couple of months. So it's important just to make sure when you're viewing this video in the future to go back and make sure that everything is still as it was today, so everything we're talking about is still relevant. And with that, I will go ahead and turn it over to Mike Koger, who can take us away into the substance of the program and talk about evidence of owners' financial arrangements.
Thanks, Jimmy. I appreciate it. So before we get into the nuances of the contractor's right to request financial information from the owner, I'd like to start by talking for a few minutes about why it's important that the contractor has this right. Mike Bamba, I'll ask you what seems like kind of a simple question, but do you have any thoughts on why this is an important right for the contractor to have?
Yeah, sure. I mean, I think it kind of boils down to, one, it's really only fair. If you think about the way most owner-contractor agreements come into play, the owner has a significant opportunity to vet the contractor through the bidding and negotiation phase before they, where multiple contractors are typically competing for the project. The owner may have certain bonding requirements that the contractor has to meet. And just by having sufficient bonding capacity, there's certain assurances that contractor has been vetted by a surety and has the ability to perform the project. So the owner, before the project, has a significant opportunity to vet the viability of the contractor and its ability to perform under the contract. The contractor, however, doesn't really have that opportunity pre-project. So once you're on the project, the primary concern from the contractor is that it will be able to get paid for the work it's doing. So there needs to be some sort of opportunity for the contractor to get adequate assurances from the owner that financial arrangements are being made. You know, contractors, they're not getting a large down payment or advance that they're billing against. So they're at risk at least for a month's worth of work as they're continuing submitting for payment, waiting for the payment application process to work its way through the system, and then getting paid by the owner. And if you think about it, even another level down, the subs are probably even more extended because they've had to submit their billing to the contractor, then the contractor processes it and submits it to the architect and owner for certification. So it is really just a fair process by which the contractor can assure itself that, at least to a reasonable extent, that there are funds in place for it to continue doing its work.
Yeah, good point. I agree entirely. I think if you think of the way money moves on a construction project, it's not at all uncommon for a contractor to be, to have payment applications in the hundreds of thousands, if not millions of dollars every month. And that's money that they're spending and they need to funnel down to their suppliers and subs. And it puts a contractor in a very difficult position if they have to go chase an owner for that money in order to pay all of the folks that they need to be paying on the project. So now let's turn to the contractor's right itself, and it comes from Section 2.2 of the A201-2017. That's the general conditions of the construction contract. And the contractor's right to receive financial information from the owner depends on when the contractor is making the request. Generally speaking, the contractor has very broad rights to request information before commencement of the work, but those rights are reduced once the project has actually been started and the contractor has commenced work on it. Section 2.2.1 is where we find the contractor's right before commencement of the work. And that section states that prior to commencement of the work and upon written request by the contractor, the owner shall furnish to the contractor reasonable evidence that the owner has made financial arrangements to fulfill the owner's obligations under the contract. So, gentlemen, I think this is a place that we should probably pause and talk about the phrase reasonable evidence for a few minutes. I think that's a phrase that attorneys are going to be familiar with and a concept that they're going to be familiar with. But perhaps folks who are not, attorneys might be a little bit tripped up on that. Jimmy, do you want to take a moment to talk about the reasonable standard? Maybe why do we use it in contracts, and why are we not more specific? And then also maybe talk about, who decides what is reasonable evidence?
Sure. So the reasonableness standard is used in contracts generally because it's really difficult on contracts such as these, particularly standard form contracts like the AIA's contract documents, to have a specific listing of a particular document that would satisfy this requirement in any given setting, because every project is going to be different. If the contract said something like the owner shall provide evidence in the form of a bank statement, that would be something that would be more specific, but perhaps not appropriate for every single project, maybe not even appropriate for any project, and I think we're going to talk about that a little bit later. But it's very difficult, and I would say potentially impossible, to be specific with respect to what would rise to the level of evidence sufficient to satisfy the contractor for every single project. If you're on maybe a single-family residential project, the contractor might require a different form of information versus a 50-story multifamily mixed-use high-rise. So the term reasonable evidence is used in this situation, and in a lot of contracts the term reasonable is used because it gives the parties flexibility to determine what fits in their situation. So in the vast majority of states, there's this underlying theory that when you enter into a contract, you are presumed to be entering to it and working in good faith. You are trying to adhere to the terms of the contract. And in that sense, if the contractor is entitled to this request and makes this request, then it's incumbent upon the owner to make reasonable evidence available to the contractor. In that sense, it's sort of up to the owner first to say, okay, what can I give to the contractor to satisfy the contractor's request in this situation? What makes sense for our project? Is it something like audited financials? Is it, tax documents going back 10 years? Is it the corporate structure of how this single-purpose LLC is set up? It could be any number of things or any combination of those things for a given project. And then on the back end, it's up to the contractor upon receiving it to reasonably look at this information and determine if it satisfies its requirement. Just like an owner has to be reasonable in selecting the types of documents and the types of information that it provides to the contractor in turn has to be reasonable in not requiring too much. A contractor just has to be satisfied that the owner has made financial arrangements. If the owner provides evidence of that, then the contractor should be satisfied. If looking down the line, I think part two of your question was who decides whether or not it's reasonable. If there's a dispute as to whether or not the documentation has been reasonable, in all likelihood, taking this to its logical extreme down the road, it's going to be determined by someone else, either an arbitrator, a judge, a jury, a mediator might help make that determination, but it's going to be someone else looking back at the situation that the parties were in at the time this request was made. So if we're talking 2.2.1, then you're talking prior to commencement of work, what type of project was this and what type of information was provided over by the owner. And if, for example, a judge looks at that and says, well, you're talking, let's use that 50-story high-rise example, you're talking a 50-story high-rise multifamily mixed-use project and the owner turned over a one-page balance sheet, for example? Well, a judge in all likelihood is going to look back at that and say, probably was unreasonable. That's not enough really to satisfy. But on the other hand, if an owner turned over boxes and boxes and boxes of information to the contractor and the contractor still said it wasn't satisfied, well, someone after the fact, like a judge, might look at that and say, that was reasonable evidence that the owners made financial arrangements. So it's typically going to be backward looking, and the parties just have to act reasonably in evaluating whether or not the evidence turned over by the owner was reasonable.
Those are all good points, and I'm glad you mentioned that if there ever is a dispute, that a judge, a jury, an arbitration panel are the kinds of people, a neutral arbiter of the dispute is going to be who decides what's reasonable. Because I think contractors and owners, anytime you see that reasonable standard in a contract, you have to think if there's a dispute, that's probably how it would eventually be resolved if it goes all the way to that binding dispute resolution type of procedure. So I will, just before moving on that topic, I will mention I did reach out to one of our AI contract documents committee members. These are architects that help us create these contracts. And the fellow that I reached out to, he was actually very involved with creating the A201, the 2017 version. And he mentioned that when it comes down to what is reasonable evidence of the owner's ability to pay for the project, what he felt that meant was evidence of actual specifically committed financing for the project, something like a commitment letter from a lender, not just some sort of general financial statement that the owner has money somewhere. So we'll move on from that. But thank you, Jimmy, for helping us put some detail to that. And to round out this issue, the contractor is not required to begin work until the owner has provided evidence of its ability to pay for the work. And if there's a resulting delay, the contract time will be extended. The contractor's next opportunity to request financial information from the owner comes after the contractor has started work on the project. And once that happens, there needs to be what I'll call a triggering event in order for the contractor to request financial information from the owner. And these triggering events are as follow. They come kind of in the midsection of section 2.2.2. And I'll just list them off here, and we'll talk in a little bit more detail about one of them in particular. If the owner fails to make payments to the contractor as the contract documents require, that's pretty obvious. 2, the contractor identifies in writing a reasonable concern regarding the owner's ability to make payment when due. Or 3, a change in the work materially changes the contract sum. So, as I mentioned, events 1 and 3 are fairly straightforward, although I can imagine that there would be some debate on the third event as to what is a material change in the contract sum. But it is event number 2 that's, I think, most ripe for debate and probably the most likely to come up due to issues we're facing with COVID-19. So I'd like to, Mike and Jimmy, I'd like to ask you guys a few hypotheticals, and maybe we can just talk about what we think are reasonable concerns, realizing that, of course, this is a flexible standard and that it is very fact-specific. So I'm just going to throw out some hypotheticals. If you guys have some of your own, then let's talk about those as well. But the first one, I guess the most obvious one to me, is if a company files for bankruptcy. And right now we've heard of a number of companies already due to the economic disruption that COVID-19 has caused. We've heard of a few companies that are actually filing for bankruptcy. And bankruptcy, a company can still continue to conduct business, but obviously there's some pretty big indicators of financial problems there. Do we all agree that that is a reasonable concern about the owner's ability to make payment?
I don't see how an owner could argue it otherwise under those circumstances. A contractor is going to need to know what the owner's plan is. Are they going to restructure and come out of bankruptcy? Are they possibly just going to fold and go away? The contractor is going to need to know, and they're going to need to know quickly.
Yep. Completely agree. So now we'll get into kind of more, what I think is more interesting questions. What about companies that have been reported to be considering bankruptcy? Maybe they've hired a law firm and there's been news reports out there. Jimmy, I'll go to you. What do you think about that one? Do you think that rises to the level of a reasonable concern?
So I think that this question, it's an interesting question. I think it kind of, you have to look at it as to when it happened. If you're talking a year ago and it's approaching summer 2019, maybe not. There's no indication that the market's really going to take a downturn. Maybe this company has had solid financials for years. There's been payments on this project for years, and there's a rumor about some bankruptcy, in some other jurisdiction or something like that. Yeah, maybe not. And again, maybe, but maybe not. In the middle of a global pandemic, when the economy looks like it's headed for a recession, I think you kind of slide to the other end of the scale and say, probably. I don't think you can say with 100% certainty, because again, it's reasonableness. The contractor just has to have a reasonable concern. But I think someone looking back after the fact at a contractor's request would probably have a difficult time saying a contractor was unreasonable in making this request if they had heard, rumors or otherwise, that an owner was preparing to file for bankruptcy in late April of 2020. I think that would be a difficult argument to make that request was not reasonable. What do you think about that?
Yeah, I agree. I mean, it all has to be taken into context, but at least and I won't mention any companies by name in this video, but the companies that I've heard that are close to bankruptcy, that have a potentially impending bankruptcy, are companies that are getting no money in the door right now, and it is is something that is happening very quickly. So I agree that all those kind of factors have to be taken into consideration. Mike Bamba, I'm going to go to you with kind of the next hypothetical. What if I think everybody can relate to this on some level. What if you're talking about an owner who's working, or a contractor who's working for an owner, just general fear in the marketplace over the economic impacts of the coronavirus. And let's say that it's maybe a publicly traded company, and you're a contractor and you're looking, and their stock price has gone down 20 to 30% or so over the last 2 months. Do you think just those general fears and maybe the stock price or the valuation of the company going down is enough to trigger a reasonable concern to request financial information from the owner?
I don't know. I guess I doubt that a general fear justifies a reasonable concern. I think I would feel safer if, from the contractor's perspective, in requesting this type of information, if the concern needs to be a little more specific to the owner that you're dealing with. So, in our previous examples, we were talking about an actual filing of bankruptcy by the owner, or specific rumors and concerns that this owner was going to be filing for bankruptcy soon. If the owner is a publicly traded company and its stock has taken a hit, but most stocks in the Dow and S&P 500 are down, X percent. There's been a little bit of a rebound as of today, but industry-wide stocks have taken a hit. So, that in and of itself, I would be a little hard pressed to say that would rise to reasonable concern. But if you're looking at it though from a perspective of nowadays, when there's a lot of uncertainty in the economy, and you are working for an owner whose stock has taken an even harder hit than some of the other industries out there, maybe a disproportionately harder hit, or it's in an industry that isn't expected to recover, you might start to come over that threshold on that sort of sliding scale of what's a reasonable concern versus not a reasonable concern. And it may make it, it may turn into something that's reasonable. Again, with all of these types of questions, you're talking about a reasonableness standard, and unfortunately, for the parties involved in it. There's no way to say that X, Y, and Z would be a reasonable concern. A, B, and C are not reasonable concerns. You really you're making the best call you can, and then someone after the fact, looking back at the totality of circumstances, will determine whether or not it's reasonable. But I hope that through this discussion, people can understand a little bit of how, the circumstances can impact what takes it from not being reasonable to reasonable. But I do think that what's key to take away is that there needs to be something that's specific to the owner that you're dealing with as a contractor to get over that threshold of reasonableness.
Yeah, I think that's a good point. And I definitely feel a little bit conflicted to some degree on this one because there are a number of companies right now that are having fears over economic downturn and the kind of implication that has for their construction projects. Jimmy, do you feel the same way as Mike does when it comes to just fears and stock prices going down? Do you think those are enough, or do you think there needs to be something that's a little bit more specific?
Yeah, I think this is one of the harder ones. I think it's all situational dependent, like Mike said, and I tend to agree with Mike Bauma's analysis insofar as it's just sort of, you wake up one day and you realize that the COVID-19 pandemic is here, and you're in the construction industry. That might not be enough, but if it's in a particular industry or particular locality, then maybe it is. This is also somewhere, and a lot of our videos touch on this as well, it's somewhere where project communication between project personnel is very important. And maybe it's not a formal request under 2.2.2, but maybe it's just, at a weekly project team meeting, you just kind of say, how are you guys looking? And if you have a good relationship with the owner's representative, the architect, the contractor, the subs, if everyone is talking, then maybe you never get there because you get the kind of assurances that you can at the project meeting. You go forward and you sort of see what happens at the next month's payment requisition cycle. But it also could be the kind of thing where it doesn't necessarily need to be a formal request. If you can kind of just make a phone call, send an email, discuss during a project meeting, and see what happens through those channels before you go ahead and make the formal payment as well. So that could be another option that contractors consider before even having to think about whether or not this formal request is reasonable and all that.
Yep, very good point. And I do agree with something that Mike, you said earlier, that the economic downturn that we've experienced has affected different segments of differently. For example, travel, tourism, hotel chains, those are companies that have all been hit in a much more significant way than IT, companies and those kind of things. So I think that there's probably some distinctions there that would make a difference as to what is a reasonable concern. Some other things that have been identified in the past that we have talked over, outside of this video are if the owner hasn't paid on other projects and the contractor has heard of those kind of payment problems, if the owner has paid late on, past applications for payment. Those are all the kind of things that might rise to the level of a reasonable concern. So any other thoughts on this topic before we move on, gentlemen?
Yeah, I actually did think of something when you guys were chatting earlier. From the contractor, again, you're looking at this specific contractor and owner to try and determine what's reasonable. If on the previous slide we talked about that the contractor is not even required to commence, it can request reasonable evidence before it's even required to commence the work. There isn't a qualifier of reasonable concern. So, it may be a good practice for a contractor to regularly, before it commences work, request sort of that financial information, because that then is a baseline of information that the contractor now has. And so, if they're dealing with an owner who's a single-purpose entity formed just to, do a residential building, and they request financial information before the project commences. And it looks like it's a little lightly funded, and so there's some level of concern, but they begin to commence work. You throw in, some economic downturn and some other factors that could cause concern. If you're starting from a baseline of having a thinly financed organization that you're dealing with, and you throw in a little bit more turmoil, then I think that it's easier to get to that level of reasonable concern. The more information you have from the owner to start, the easier it is to make that reasonableness determination. So, I think, we ended up talking, we kind of talk about these as like one section at a time, but if you think of them as a project flow, you can use a contractor should be able to use that to their advantage. And I don't think owners should look at a request from a contractor for proof of financial arrangements before commencement of the work as a negative. It should just be good business practice on the contractor's part, and an owner shouldn't take it as a negative.
Yeah, no, very good point. And it's a good way of pointing out that the contractor's right to request this kind of information is much broader before they start work. So if you want to know these kinds of things, it's good to think ahead and request it before they actually start work, so you don't have to, cross some threshold of what is a reasonable concern. So moving on a little bit, I won't read the rest of section 2.2, but there are a couple of important things I'll just briefly touch on. First, if the owner has not provided reasonable evidence within 14 days of the contractor's request, the contractor has the right to immediately stop the work, provided that the contractor notifies the owner of that stoppage. Now, Mike, just kind of real quickly, I know you've fielded this question a few times in the past, but what does the contractor have to do to satisfy that notice requirement?
Yeah, it's a written notice. If anyone cared enough to compare the 2007 version of the 8201 to the 2017 version, you'll note that it used to be every time we wrote the word notify or notice, we would qualify it with the word written. And then in the 2017 documents, we've made the concerted effort to avoid writing written over and over and over again. But the requirement that the notice be written is still there, because we added a section that says all requirements to notify the other party or all requirements to provide notice must be in writing. And I think for the first time, though, the 8201 recognizes electronic transmission as a means to satisfy written notice, except when you're dealing with a claim, but we're getting too far afield from this presentation. So that's another video. Yeah. So, the contractor must provide written notice to the owner in this section.
Good point. Okay, so moving on from that, so just to kind of, I guess, fine-tune this point a little bit, this section is very clear that if the owner has provided no financial information at all, that after those 14 days are up, the contractor can stop work. But I think there's an interesting kind of topic that we should maybe talk about briefly, is what happens if the owner provides some form of financial evidence, but the contractor disagrees that it's adequate. We've researched the case law. I'm fairly certain there's nothing out there where this has actually risen to the level of, a court writing an opinion about it. But Jimmy, do you have any thoughts on how that topic might work itself out?
Yeah, so I think this is an interesting concept, and it's a little bit difficult to follow how it's triggered, but it all arises in the sentence that is highlighted on the screen there that starts with, if the owner fails to provide such evidence. And what is meant by such evidence? Well, such evidence refers to reasonable evidence above in the same paragraph, reasonable evidence that the owner has made financial arrangements. So where this gets tricky is if the owner provides something, but maybe it's not reasonable evidence that the owner's made financial arrangements. So where this gets interesting is there's sort of three possibilities, right? Contractor makes a request, and then you pause there, and then three things can happen. Number one, the owner provides nothing in response, no response, period. 2, the owner provides something, and I'll use a silly example just to get the point across. Like it sends over like a 2-word email that just says we're good. And then, the other extreme is a dozen banker's boxes full of audited financial records of the single purpose LLC that's financing this project, like the most you could ask for, right? So I think under the extremes, it's really easy to understand what happens. So if the owner provides nothing, then of course it's failed to provide such evidence, and then the contractor, within 14 days, and the contractor may immediately stop work. If you go to the other extreme and say the owner provides a dozen banker's boxes full of information, well, the owner's provided evidence as required, and everyone's good to go. But if the owner provides something in the middle, where let's say nobody, like no one in their right mind would think that it is reasonable evidence that the owner has made financial arrangements, then what happens? Well, the owner is going to say, no, we sent something, but it was entirely unreasonable amount of information. And the contractor is going to say, no, you didn't. In that case, there's this sort of interesting little nuance that occurs when if the owner provides that information, the contractor can immediately stop work. But then the issue becomes, is that a claim? And we sort of just mentioned claims a second ago, and a claim, not to get too far afield within the the nuances of the A201, but there are certain things that occur if a claim is triggered, and one of those things is the contractor has an obligation to continue with its work. So if the contractor has to file a claim and say you did not provide sufficient information, and there is a disagreement as to that, there's this sort of issue that arises with whether or not the contractor can immediately stop work right then, or does it have a continuing obligation to perform its work under the contract during the pendency of a claim, which is discussed elsewhere in the A201. So it's sort of an interesting issue, and I know we're not sort of focused on that too much right now, but that's something that might arise, and I think it's sort of where along the line and this sliding scale the sufficiency of the owner's information. If it's just a dispute as to whether or not the information is reasonable, like a banker's box or 2 of information, like something legitimate, but maybe it's reasonable, maybe it's not. I think that is probably more along the lines of it's a claim and the contractor has an obligation to continue its work. If it's nothing, the owner has provided nothing or essentially nothing, like the you're good text or email or like a thumbs up emoji or something, then it's probably equivalent to sending you might as well have sent nothing, and in that case the contractor may very well be within its rights to immediately stop work because there isn't even a claim at that point. There's no dispute as to whether or not that's a reasonable amount of information. So it's sort of this interesting little nuance right there. Does that answer your question? Is that what you were looking for?
Yeah, no, that's excellent. I think that is definitely provided what I was hoping, which is that there is some kind of gray area as far as what the evidence that the owner gives back to the contractor, and the contractor needs to know what its recourse is. So if we can distill something of a rule, it sounds to me like if there's a good faith dispute over whether or not the evidence that the owner has provided is reasonable evidence, then we find ourselves if you look further into the A201, into Article 15, that a dispute is classified as a claim, and during a pending claim, there is an obligation for the contractor to continue performance of the contract until that claim is resolved. Mike, is that the way you see this working?
Yeah, I think when you have a reasonable dispute, you've moved into the claim category, and this is going to be especially true when the original request from the contractor arised under that subparagraph 2, where the contractor had whether or not there was reasonable concern, because that's going to impact probably how much the owner is going to turn over. If they don't really think it's a reasonable concern, they're going to go with the "Yup, we're good" type email or something closer to it. I would note that if the request follows the owner's failure to pay the contractor, the evaluation is a little different, mostly because there's another section in the A201 that says if the owner fails to pay the contractor, the contractor can stop work. So while that original non-payment is, if it's remedied, then you kind of get back into the same determination we were just talking about on whether or not there's been reasonable evidence provided such that the contractor would then return to work. If the owner never satisfies the payment, I think it's section 9.7, allows the contractor to stop work and is excused from continued contract performance. So, if you're talking about a subparagraph 1 situation, until the owner remedies that non-payment, the contractor can stop work. But as soon as it's been paid, then you're into the exact same scenario we just talked about. Has there been reasonable evidence provided? And you could end up in a claim situation where the contractor has to continue performing, assuming they keep on getting paid, and go from there. It's really time, I suppose, for both parties on whether or not how much to dig in on this topic. Are they really going to stop the project, the contractor, and is the owner really going to stonewall on providing evidence? Because ultimately there'll have to be a decision on whether or not their behavior was reasonable, and whoever's determined to have not acted reasonably is probably going to have some consequences associated with those decisions.
To follow up on that, Mike Bama, that just raised an interesting point in my mind. I won't spend too much time on this, but it's sort of like, let's assume you have monthly payment requisitions and pay applications. Then, this issue should be resolved and answered within 30 days because, let's assume the contractor is paid for last month's. Well, then it wasn't an issue last month because the contractor got paid. If it becomes an issue this month, then the contractor and the owner are both going to know within 30 days, likely, whether or not the owner has the ability to make payment, because that question will get answered, right? Whether the owner makes payment or not. So this issue sort of only happens in the interim when it might be the middle of the month and the contractor is trying to figure out whether or not they continue to work for the rest of the month until they submit their pay app, and then they're going to know this question is going to be answered. So either it was well-founded or it wasn't. I did some quick research. I wasn't able to find any case law that talked about that specific issue. Like if a contractor raises the issue and says an owner, doesn't have financial arrangements in place, and then an owner does or does not make next month's payment, does that answer the question? Does hindsight make the contractor reasonable in its request? If the owner eventually fails to make payment next month, can the contractor say, well, see, I was reasonable last month? Or if the owner makes payment, can the owner say, see, your request was unreasonable because thumbs up, we're good? So that it's sort of an interesting little quick analysis that happens within 1 month at a time as to this particular issue.
So just to kind of finish up on a couple of topics that also deal around this contractor's right to request financial information of the owner. In section 2.2.3, there is a requirement that once the owner has furnished evidence of financial arrangements, the owner shall not materially vary them without notifying the contractor. And also in section 2.2.4, it's likely that the information that the owner provides to the contractor is going to be sensitive in some manner. It's financial information. It might be information about loans that the owner has taken out. So under section 2.2.4, the owner has the ability to designate information as confidential. Gentlemen, before I close out, any other final thoughts on the contractor's right to request financial information from the owner?
Nothing from me. I hope we have thoroughly discussed all the great and downsides of a reasonableness standard. You never know going in, so you got to do the best you can.
Exactly. So if you have any questions about AIA contract documents, feel free to contact us at Documents Information. We have an email address that's on the screen here. It's docinfo@aiacontracts.org. You can also call in and talk to us. We can't provide legal advice, but we can definitely tell you about the AIA contract documents. Also visit our website at aiacontracts.org and find information about other videos like this on our YouTube page. Thank you very much.